Dear ladies and gentlemen, thank you so much. I have good news and bad news in the beginning. Good news, I'm the last speaker before the lunch break. Bad news, the topic is extremely long. Topic is extremely long. If you look at the title, I left it as in the working stage because the technical title would be so boring that I would like to speak about certain legal challenges of the pre-trial phase. But otherwise, it's a very good title. Thank you so much for the organizers for giving it to me, because actually it gives me the table of contents right at the beginning. Because I'm going to speak about three major set of issues. First, jurisdiction, then the trigger mechanisms, and lastly, I'm going to address certain issues of the admissibility questions. But honestly, the selection of issues is going to be arbitrary. At this point, because there's a very wide range. I try to cover as much as possible and then detail some of them in the Q&A, definitely in the paper coming up. So let's start with jurisdiction. Honestly, thinking about the ICC at 25 forces me to admit some personal connections to the ICC. I'm a very lazy man. And it was also true during my legal studies. And in 1998, when the Rome Statute was signed, I was in my fourth year of studies, and I had to choose a topic for my minor interim thesis. My former supervisor is sitting here in the first row, Péter. Thank you so much for letting me pass. I decided that I'm going to write about the ICC because it was so new. It was just 2 weeks old. It's a good topic, not too many readings. I was wrong. Of course, and I'm still doing the readers ever since then, and I'm not finished. But that's what I do. And when I first started to read, I saw that jurisdiction must be boring. It's procedural law. And it's a mandatory stuff that we do in the beginning because we know that every procedure is based upon some kind of jurisdiction. It's a very short list. We can learn about temporal jurisdiction, subject matter jurisdiction, personal jurisdiction, first 10 articles of the Rome Statute and you are said and done. And that's when it becomes exciting, at least for me, because when you start to challenge the trivial issues, and real life started to challenge these trivial issues in the last 25 years from every possible aspect. Even temporal jurisdiction, which seems pretty much straightforward, because as far as my limited understanding of natural sciences goes, time goes from here to here. It's, well, of course, 4-dimensional, yes, but I'm a lawyer, so for me, time is linear. And I saw that if an event happens after a certain other event, namely entry into force of the Rome Statute for that particular state party, the court should have jurisdiction. And then came the situation in the Philippines, when the state says that, okay, I admit that the court had jurisdiction, but now I change my mind. I withdraw my consent. Now what happens? And we have a reasonable answer to that. And the court exactly followed this reasonable answer. But actually it is settled. And this is a trivial matter, but now we have a standing case law on what happens when a state withdraws consent. We know it to the date, to the day what happens. So it's very precisely we can set temporal challenges. What about subject matter jurisdiction? There will be several presentations on that, so I'm going to refrain from going into details about crime of aggression, crimes against humanity, war crimes. These are detailed by other speakers. So if you don't mind, I would turn my attention and draw your attention to territorial challenges of the court, which otherwise seem also a crucial issue for anything international law related, because we work with sovereignty, and when it comes to sovereignty, the primary aspect is territoriality, at least throughout the 20th century. And what about these territorial challenges? Of course, if there are, the first thing that came to my mind when preparing for this presentation is disputed territories, because that's an issue which haunts me ever since I tried to finish my PhD, also supervised by Péter, so thank you so much also for that. And in that research, It was done in 2009, 2010. So I think some of you already know what caught my attention. Yes, it was the conflict in Georgia. What happens when the alleged crimes are committed in a territory which is considered by the territory of a state party by one part of the world, while another part of the world, albeit smaller part of the world, considers it to be part of a non-state party. So the ICC must take a position in deciding questions of general international law, deciding questions of statehood, but the ICC has no mandate to do that. So it's a task which is prohibited, but necessary for the ICC to finish their work. I think that's a beautiful challenge and rhymes beautifully with the Darrell Robinson citation that we have read a few minutes before. So when it comes to disputed territories, okay, we have a list in our minds, long-standing disputed territories like Nagorno-Karabakh between Armenia and Azerbaijan, but none of the parties mentioned are state parties to the Rome Statute. So it's out of the question for us. So at least we have one state party in the Rome Statute in order to have a relevant equation that we can solve. And that leads us to the conflict in Georgia, partly to the conflict in the current ongoing conflict in Ukraine. I will get to that. So what about the Georgian conflict? I know most of you have heard about it. Most of you are possibly bigger experts on that than myself. But we know that there were some disputed territories between Georgia and Russia, South Ossetia and Abkhazia. But what really happened, what is the source of the controversy? I don't want to bore you and waste my time on the historical details. The Office of the Prosecutor submitted a request to the pretrial chamber. Sorry, Peter, I'm also citing you, but you were sitting there. And honestly, again, preparing for this presentation, I realized that when you were sitting in my PhD defense, I think none of us ever believed that you are going to have to decide these questions. And thank you for that, too. So, about South Ossetia, the Office of the Prosecutor prepared a very good request for the pretrial chamber, where they summarize what happened. And for me, there is one captivating, very symbolic event to describe you the controversy behind the debate. I think in 2006, 2 years before the actual armed conflict broke out, there was an election in South Ossetia. Actually, there were two. One of them was the official, the other was a counter-referendum. One of them was organized by the Russian-controlled territories, the other on the Georgian-controlled territories. Guess the results. Both are near 100%. So if you want to place your argument on traditional notions of government recognition, self-determination, you are going to fail spectacularly. Because we have two referendums almost unilaterally at the same moment from the same country. Now you decide. And actually, that's also a rhetorical challenge. How do you describe South Ossetia without making a description, without making a decision whether South Ossetia is a country or not? You have to make an argument without naming the party. And, well, the linguistic challenge is done in the ICC materials. Persistently, they call it de facto territory, de facto authorities, de facto president, and that little two-word Latinism solves this challenge. And in this paper, the Office of the Prosecutor actually submitted a position which was accepted by the pretrial chamber, and correct me if I'm wrong, but this statement was accepted unanimously. So your concurrent reasoning did not affect this statement, that the chamber agrees with the submission that South Ossetia is to be considered as part of Georgia. We could have a full stop at the end. That's a very straightforward sentence. The matter is decided. As it is generally not considered an independent state, and so on and so forth, the reasoning goes on. So we first have a disputed territory decided by the ICC. And then we have another issue, What if the territory is not disputed? The territory is disputed too, but what if the very existence of the state is disputed? And of course, it comes to the nightmare of every international lawyer, the question of Palestine in the Middle East. Is it a state or is it not a state? And of course, we have an answer that we can make, but the ICC cannot make that answer. But they had to, again, because now we have, or we have the situation in Palestine. Contrary to the Georgian situation, so like the Georgian situation, it was also a self-referral. I'm rushing forward to the trigger mechanisms, but the entity calling itself the State of Palestine referred the situation to the ICC. The question is it really a state? Does it have the right to refer a situation happening on its territory? And the OTP was very careful, and they made a decision that they see that, well, it was settled by the Assembly of State Parties. So we did not want to overrule, but it's like the OTP did not want to decide it on their own. So they again submitted a request, again for the pretrial chamber, again, but Peter sitting in it, but this time you had a dissenting opinion, which is actually twice as long as the original judgment. So the OTP was right. I think if I conclude, if I try to draw a baseline between the majority opinion and Judge Kovac's opinion, is that the complex legal issues are there. So it's really a swamp of international law. Everything is there. And you have to decide a number of issues like the Oslo Accords that have been mentioned in the keynote speech also. What is the legal nature of those? What are the legal nature of the UNSC resolutions? What are the rules of interpretation applicable to the present situation? But basically, the majority opinion decided that because the General Assembly, the United Nations General Assembly, has accepted Palestine as a non-member observer state, although we know that this category is not based on the UN Charter, as a result, Palestine would be able to become a party to any treaties. And it's up to the Assembly of State Parties to decide any disputes about this, but there were no disputes to be settled by the ASP. So Palestine had a right. Actually, outreach materials of the ICC that I have read explained is that the ICC did not decide on the statehood of Palestine, but decided only on the territorial scope of the investigation, which is a beautiful downplay of what actually happened. In my understanding, and I understand that with an ICC judge in the court, in the room, he cannot really make any statement on this, but at least not publicly. The ICC was forced into a position which no criminal judge likes, to be a politician, to decide a matter of general public international law, and I think it was a brilliant way to avoid it. We have a Hungarian folktale about a very clever girl who managed to perform certain opposing tasks given to her by the king. And this is answering the question without answering the question. And I think that's a masterpiece in that. I have 5.5 minutes left. So here is the first temporary conclusion I try to draw about jurisdiction so far. The lesson, here we have lessons learned to cite the title of the conference. The lesson learned is, if you look at the the Georgian situation, the Palestinian situation, I think the lesson learned in plain English is the ICC is not a fool. The ICC measures two values highly, at least in my understanding. Legality, I mean the scope of their power, as any international organization must do. And otherwise, these decisions are very reasonable. So behind the camouflage legality that Russia put as a veil on the Georgian situation, they pointed out, no, it's Georgia. So it's a very reasonable decision that I actually like intellectually. So what about the next block in the pretrial phase, trigger mechanisms. Something, again on a personal note, I have to tell you, I have been writing and reading about the International Criminal Court for 25 years now. And for me, it never became boring. It keeps surprising me. And actually, I would not have believed that in 25 years, all of the trigger mechanisms would be thoroughly tested, except for the one special trigger designed for the crime of aggression by the Kampala resolutions. But all the general trigger mechanisms have been thoroughly tested. I think some of you may remember those fears that we don't want proprio motu prosecutions. That was a thing in the late 1990s, that people were afraid of an international Ken Starr. Who remembers Kenneth Starr? He was the prosecutor in the infringement procedure against Bill Clinton. Who remembers Bill Clinton? Yeah. But basically, all of the prosecutors so far that we had at the ICC used their proprio motu powers. And there are lots of tests developed by the ICC pretrial chambers and the Office of the Prosecutor and the defense counsels, actually. Don't forget about them. So there were, as far as, if my list, I think it's comprehensive, the Kenyan, the Georgian, the Burundi, Afghanistan, and the Philippines situations were proprio motu procedures. These are not really ICC success stories. If we start to measure effectiveness in terms of cases finished, this is not on the top of the list. On the top of the list, we find state party referrals, namely self-referrals. DRC1, Uganda, Central African Republic, Mali, Central African Republic, Chapter 2. Also, there was a fear in the 1990s that we should not allow other parties to refer situations because that would lead to, wait for it, politicization. I managed to say it out loud without breaking the word. Politicization. It's a fear. Overwhelming, that I understand and agree. But there were two, Venezuela and the Ukraine. The Venezuelan situation was submitted by 6 American countries. Ukraine, over 40. I don't really know where the counter stopped. So it's not really political. It's not one state referring the situation in another. It's multiple states. It's a valid representation of the international community referring the situation in another country. So we have experiences for all of them. And yes, of course, we have experiences for Security Council's referrals and also for deferrals. Because as far as I remember, we never really had a situation in Liberia. So again, considering the time is running out of my hands, lessons learned about triggers, all of them tested, good things. Politicization so far avoided. Lessons to be learned, well, with regard to the United Nations Security Council, there are still some open issues that I'm not going to list here due to the shortage of time. Turning now to my final point, admissibility. At the Rome Conference, many issues of admissibility were deliberately left controversial, like my favorite example, the word genuine, which was decided by the head of the working commission arriving with the Oxford English Dictionary in his armpit, opening it and finding a meaning that nobody is using for an adverb which they were suffering to include because you don't want to insult the states that you want to rely on. You cannot say that, hey, states, you should have effective criminal jurisdiction. What is effective criminal jurisdiction? We had a brilliant presentation on that. And just the methodology would require a whole conference to finish. So instead of saying effective, real, whatever, meaningful modifiers, we came up with the word genuine. What is genuine? Who knows? I have several papers on that, but nobody cares, so I'm going to move on. Because with admissibility, we have finally a situation that had been decided by the prosecutor that the state The relevant state is doing so well that I'm going to give back the position. And that's Colombia, 2021. We need more Colombia to have well-sustained conclusions. So I'm going to stop here and draw the lessons about admissibility. There are plenty of lessons learned, plenty of tests developed by the ICC, like the same person, same conduct test. We know the order of the hierarchy between the national authorities. We have beautiful policy papers on complementarity. Actually, a new one is coming up in 2023. I don't know if it's out there yet, but I haven't found it so far. Maybe it's my bad. But there are many traces in many aspects. There were plenty of Article 19 challenges made, so it's high time that the arguments made by states can be summarized, and it will be done in my paper. But there are still open issues. Lessons not unlearned, but being learned for the moment, and that's the qualitative requirements of a national procedure. What is a genuine procedure? We have some traces in human rights litigation, we have some traces in international criminal litigation, but I think the clear test, like the one in the same person, same conduct test, is yet missing. And although I'm not sharing you with my slides because this is really, trust me, I'm a lawyer, this is really just for me, I reached my conclusions, and I'm going to make it very brief. At the stock taking of the pretrial phase at 25 today, I think I can state that the beginning stage of international criminal law is over. We have seen, not the beginning of an end, but we are through the end of the beginning. Now it comes of age, right before our very eyes. Major milestones have been reached. And I know that in 2011, in my PhD defense, we never saw that someone from the room has to decide this question. But I think nobody in their right mind would believe that in 12 years, the ICC is going to issue an arrest warrant against the president of a P5 member state. And I would stop here for a moment because that's a major milestone. I know that there will be very many conflicting opinions for the lunch break or even for the Q&A. But I do consider this as a turning point in the history of international criminal law. I know that many of us have been asked by the general media. With my friend Tamás Hoffman, we have attended some of these events, sometimes even together, trying to explain why it is a good thing if nobody believes that someone in Moscow is going to arrest President Vladimir Putin this morning. Maybe it happens. But I have one concluding argument in that. There is one lesson that the world has to learn about international criminal law. It is patient. It is very much patient. I think nobody believed that Omar Hassan al-Bashir is going to fear retribution when he famously toured around the world, shaking hands with politicians. Compare it to the fact that Vladimir Putin, and who is more powerful from the two? Al-Bashir or Putin? And al-Bashir was touring around the world just 10 years ago, and Putin did not attend the BRICS meeting, the historical BRICS meeting. I think that tells something about the achievements that have been done. And also the preventive function of the international criminal law has been mentioned. I would try to conclude my presentation with citing something that we usually are too shy to mention. International criminal law has a retributive function too. It is a tool of revenge on behalf of the victims. And revenge is best served cold, as we know it. And I might be a bad Catholic and a sadistic psychopath. Some of my students are here, so finally I admitted it publicly. But it gives me some ultimate comfort to know that the ICC at 25 has already reached a position that, Your Honors, you leave no good sleep for the wicked. And thank you so much for that, and thank you for your attention.